Hello and welcome to the EDRM Global Webinar channel. My name's Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is an EDRM collaboration with eDiscovery. Today's Doug Austin called Important eDiscovery Case Law Decisions for May 2022. Our faculty experts are the aforementioned Doug Austin, the illustrious Tom O'Connor, and the Honorable Judge Andrew Peck. We welcome your questions and feedback in the console. This webinar will be recorded and available for replay at your convenience, as are all of our webinars, including our case law webinars. Please look at the attachments tab for a link to subscribe to eDiscovery today, and to Judge Peck, Tom O., everybody over at JD Supra, a registration link for next month's case law webinar, and a link to find Kaylee and me in real life as we co-host with Everlaw in Chicago next week, then New York, then LA. We would love to see you. And you can download a certificate of attendance from the console after the webinar to use for your continuing ed requirements. Now, our friend Doug Austin, the editor of our EDRM partner eDiscovery today, has over a decade of experience in the trenches of eDiscovery. He has been posting at least once each business day since 2010, and I just talked to somebody who said he reads you every day, and sometimes 3 times. Doug earned Reader's Choice Awards from JD Supra in eDiscovery and Cyber back in the day, and he will win again in 2022. So Tom, it's got to be preemptive, guys. And Tom O'Connor, hailing from the great city of New Orleans for 3 decades. He's stewarded the Gulf Coast Legal Technology Technology Center. He's a sought-out consultant on some of the largest cases, and most recently, the opioids. And the Honorable Judge Andrew Peck retired as a federal magistrate judge in the Southern District after 20 years, not before he wrote many of our first opinions. eDiscovery generally, keyword search terms, boilerplate objections, the beloved 502D orders, and technology-assisted review. He's a graduate of Duke, and now with DLA Piper, he advises on information management, particularly in the eDiscovery context, also acts as a mediator, arbitrator, and special master. And we at EDRM are so grateful for Judge Peck, Doug, and Tom O. for serving on our EDRM Global Advisory Council. And Doug, you've got more than a couple of cases today. Some very interesting ones.
Indeed, we do, Mary. We may have our most interesting 6 cases ever this month, and hopefully Houston thunderstorms hold off long enough for me to present them all. So our cases include sanctions requests for inferences with a unique analysis on one of them, a dispute over former production of Salesforce data, disputes over email threading and privilege logs, ESI protocol disputes over search obligations and terms, and admissibility of Wayback Machine evidence. The best part of it is that most of these cases were suggested by Judge Peck and Tom, so that made my job easier. And as always, we'll look to hopefully save a few minutes at the end for questions, but we encourage them along the way as well while we're discussing each case. And just a reminder, we will send out a copy of the slides after the presentation, so look for that. So if you're looking for the slides, don't worry, you will get them afterwards. Of course, any ideas expressed by us here today are our own, not those of our organizations, clients, or partners. You may know that by now. Don't have to say it. And before we get started with these cases, here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling where you can check out the full ruling itself. These case law rulings are available courtesy of Kelly Twigger's eDiscovery Assistance site, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery. eDiscovery Assistant has over 22,500 lifetimes all rulings. eDiscovery Assistant is the definitive source for eDiscovery case law out there. So with that in mind, let's get into our cases. And our first one, suggested by Judge Peck, has a unique analysis regarding spoliation and sanctions. Instead of basing the analysis just on Rule 37E, the parties in the court decided to leave it to Beaven. So versus Target Stores. Come on.
I saw what you did there, Doug.
He stole my line. I was going to say that.
I had to get there first, Tom. So Rose versus Target Stores is a slip and fall case at one of the defendant's stores where there was a discovery dispute regarding whether the defendant withheld and destroyed a prior incident report. The plaintiff claimed doing so warranted an adverse inference jury instruction on spoliation, while the defendant said that the plaintiff should have pursued the issue earlier, if at all, with a motion to compel filed before discovery closed. And by the way, the defendant didn't consider the document to be responsive anyway. Both parties cited a three-pronged test in their argument known as the Beaven Analysis, that a party seeking an adverse inference instruction based on the destruction of evidence must establish that the party having control over the evidence had an obligation to preserve it at the time it was destroyed, that the records were destroyed with a culpable state of mind, and that the destroyed evidence was relevant to the party's claim or defense. After first finding that plaintiff has failed to articulate sufficient facts to suggest defendant intentionally withheld relevant information from her, and absent such facts, the plaintiff cannot prevail under Rule 37E2's stringent standard, Tennessee District Judge Mark Norris then turned to the Beaven standard analysis. Finding the plaintiff failed to meet the first prong, he stated, defendant hotly contests the responsiveness of the document plaintiff presently seeks because it indisputably would have been created 22 months prior to plaintiff's incident, and a party need not produce information it considers to be irrelevant during discovery, absent a court order on a motion to compel that affirms the sought information's relevance. Norris also rejected the second Beaven prong and denying the plaintiff's motion stated, plaintiff's one-paragraph argument that defendant destroyed the evidence with a culpable state of mind lacks merit. Simply put, plaintiff has not alleged sufficient facts to warrant a finding that defendant acted with a culpable mental state when it refused to produce a document that it contends is not relevant. So to paraphrase Meatloaf, 2 out of 3 is bad for the plaintiff in this case. So, Tom, did the plaintiff blow it by not filing a motion to compel before discovery closed?
Well, I'm always loath to Monday morning quarterback decisions, strategic decisions, especially by firms in their choices. But here, I have to say yes, they did, and the court said it for us. Really, it's not really even a matter of interpretation. The court stated point blank, and I'm quoting here, a party need not produce information it considers to be irrelevant during discovery, absent a court order on a motion to compel that affirms the sought information's relevance. At this juncture, however, on the eve of trial, the court is wholly unprepared to make a relevancy determination about information in a document that may or may not even exist, end quote. The court just said, yeah, you waited too long. You had an opportunity to do something that would have brought the whole issue to a head and opened up discussion about it, but you didn't avail yourselves of that. So, sorry. Yeah,
timing is everything when it comes to eDiscovery motions. So, absolutely, great point, Tom. So, Judge Peck, when you were on the bench, did you ever conduct a Beaven analysis? And why would a court choose to use the Beaven analysis standard instead of the traditional Rule 37E analysis?
Well, not only did I not perform a Beaven analysis as such, I never even heard of it. And the reason for that is, in every circuit, there is a key case on a particular issue that everybody in the circuit knows and uses. But if you're in a different circuit, you have a different case for that same proposition. So, that was the Sixth Circuit. And indeed, the Sixth Circuit there, or at least that judge, referred to the test that I would have used, which was the old Second Circuit residential funding decision, a decision that has been, in essence, overruled or obviated by the advisory committee notes to Rule 37 E. That was the old, even negligence can be a form of culpable conduct that can get you a spoliation adverse inference. Well, that's gone. But essentially, the analysis, the three-part analysis, is pretty universal. Why exactly? Any court uses their old pre-2015 Rule 37 E substitute analysis, case law analysis. I'm not sure. Maybe because it wasn't clear here whether the missing information was in ESI form or perhaps a paper document, since, as we all know, 37E on its face only applies to ESI and not hard copy or physical evidence. So that, I assume, is why belt and suspenders, the court did a 37E analysis, but also relying on circuit law, a Beaven analysis.
Okay, that's interesting. Yeah, I hadn't considered that as a possibility. So great point, Judge Peck. So, Mary, obviously there was dispute on the relevance of the evidence here. So what advice do you have for our audience regarding disputes over the relevance of particular evidence?
Well, I would say that one paragraph is clearly not enough. And so looking at the claims and defenses, what's necessary to prove each element, and how would this document help you? And can you articulate that? In this case, it's an incident report from 22 months prior. Was there an obligation to save that for other reasons other than this particular lawsuit? How was it destroyed? How do you know it was destroyed? So there are other ways to get at these things, either, taking a look at other productions, with an analytic eye, later drafts, affidavits, declarations, interrogatory answers, depositions. And are they looking for a pattern? I mean, why would that document be relevant in this case? So we don't know that, and I think that's why the court said no.
Yeah, well, clearly the plaintiff didn't do enough to make a case for it. And one paragraph, like you said, is not going to make that case. So absolutely. So great point. Just a reminder, if you missed it, we will send out the slide deck after the webinar. So look for that. So you submitted that question, rest assured, you will get the slides. All right, we'll move on to our next case, which is our first of two involving trademark infringement claims with parties having similar names. In this case, the plaintiff contended that the defendants failed to preserve ESI. Why did the plaintiff think that? For starters, there was an inadvertently disclosed email from one of the defendants, which the defendant's counsel inadvertently sent to plaintiff's counsel as part of December 2021. And that email stated, quote, "We had no idea we should have printed out and or saved any emails. But if we had known we should print all email up to now, done that, but we weren't." That would be a good reason to think there was email not preserved. While the plaintiff contended that the plain meaning of the inadvertently disclosed email was that defendant ESI, the defendants responded that the plaintiff construed the email, which was part of a longer conversation about how defendants had temporarily lost access to some of their emails during a server migration, but later recovered them. The other reason the plaintiff believed ESI was missing is that it received emails from third parties via subpoena between those third parties and the defendants that the plaintiff did not receive from the defendants directly. The plaintiff filed a motion to compel in December 2021, which Magistrate Judge Ballou denied as untimely as it was after the close of discovery, and the plaintiff never filed an objection to that order. Senior District Judge Norman Moon denied the plaintiff's 11th hour motion for spoliation inferences, stating, "The court's analysis begins and is dispositively resolved by the second of the four elements mentioned above, that ESI was lost. Plaintiff has not provided any evidence that defendants lost ESI." With regard to the missing emails produced by third parties, Judge Moon said that readily explained by the fact that defense counsel did not deliver some emails between defendants and the third parties that defense counsel deemed irrelevant or privileged, while the third parties delivered everything in their possession. As for the inadvertently produced email, Judge Moon stated, the court has no reason to disbelieve defense counsel's reasonable explanation for the December 10 email that David Demiduk was initially unaware that he had to preserve emails and wished that he had printed them out and physically stored them, but that defendants and defense counsel eventually located and delivered all the requested emails. So, Judge Peck, if the plaintiff had argued the relevance of some of the emails it received from the third parties that it didn't receive from the defendants, could that have changed the outcome, assuming they filed a timely motion for sanctions?
Possibly, although, a little bit of civil procedure background here. They filed the motion to compel in front of the magistrate judge, who said it was untimely. At that point, they could have and should have filed objections with the district judge. They didn't. And by not filing objections within the 14 days called for under the rules, that issue became over. Couldn't go to the district judge with it. And since it never went to the district judge, it couldn't be raised on appeal, even if the case got to the circuit. So that was their first mistake. But assuming they had done various things timely and according to the rules, I would say that in many ways, a discovery judge, like a juror, can be moved by the evidence. And so if the plaintiff could have showed that the emails from the non-party were a fuller picture, and the only emails that the defendant actually produced were good for the defendant and not good for the plaintiff, those sort of things could be circumstantial evidence of a failure to preserve and or intent to deprive. But just, the non-party had emails, the party didn't, is sort of a so what? Why was there that discrepancy? What were those emails showing? A lot of facts like that either weren't presented to the court, or at least the court didn't bother presenting in the opinion because of the waiver issue.
Sure. No, that makes sense. So, Mary, it seems like the inadvertently disclosed email should have been easy to exclude as privileged, since it was communications between the defendant and their counsel. So what can parties do to make sure they don't let emails like that slip through the cracks?
Nice softball, Doug. Certainly.
I think I know what Mary's answer is going to be.
Well, maybe. So the, potentially privileged auto coding has been done for, over a decade, using the domain of the defendant and the defendant's counsel, and perhaps a list of all counsel, with auto coding for all of that. And, let's add in the webmail addresses. Let's add in the cell phone numbers, because now counsel is texting with the represented. And then certainly you could stratify the emails by the number of recipients. So with fewer recipients, there'd be a higher priority and possibility of privilege. We've got some machine learning quality control going on these days, incorporating human review for the high priority custodians and their counsel. But really, QCing the final production would be very, very helpful. But your question, Doug, was more about what the parties can do, not counsel. So what the parties can do is their in-house counsel or their outside counsel can train internal staff on what to put into emails to counsel that they want to be privileged. And, as we were just saying, limit recipients, keep it in-house or to the attorney and the team, putting a footer like highly confidential and privileged, created at the request of the Honorable Andrew Peck, Esquire, DLA Piper, like that. Or you can ask out loud in the writing for legal advice. The subject line, the old line on a paper memo, that's always a good place to indicate privilege. Don't copy your attorneys on everything like lunch and everything like that. It dilutes the privilege, makes you review more. And of course, international companies need to ask the advice of outside counsel because some countries don't have in-house privilege. So that's what I've got for you, Doug.
Oh, Mary, you disappointed me there. That was a perfect, I mean, it was a great answer, but you also...
Did I miss a rule?
They need a rule 502D.
Oh, the beloved 502D. Yeah, nice setup.
Sorry, Mary. I couldn't defend you on that one. But I agree with Judge Peck. It was a great answer. And actually, I really should have said, what can counsel do? Because if it were a softball question, then obviously it's not one that the defense counsel in this case knew the answer to. Otherwise, they wouldn't have closed it. So there you have it. It is still very important information to put out there. So, Tom, Judge Moon referenced the draconian nature of the sanctions the plaintiff requested. Do you think they have a case for some level of sanctions?
Well, I'm going to continue my one-word answer from our previous slide and say no. When a judge starts off a sentence that says the court's analysis begins and dispositively resolved by the second of the amendment of the elements mentioned above, the court just put an end to everything right there. He said, as you read several times, defendants and defense counsel eventually located and delivered all the requested emails, and plaintiffs, by their own contention, received all the emails from third parties. The emails were coming in left and right. He concluded by saying there's nothing in the pleadings to suggest that the emails plaintiffs believes it is not received are permanently lost, end quote. So, not permanently lost, no sanctions.
Yep, absolutely. For sure. So this was an interesting case from that standpoint. And a couple of comments here. First person, well, it's a tongue-in-cheek question. So train employees to better hide malfeasance rather than disclose and resolve same, with a winky smiley face. And then another comment, given that ESI was not lost, Rule 37E would not apply, but setting aside questions of privilege and timeliness of plaintiff's motion, would the plaintiff have been better served by moving for sanctions under Rule 26C1? Because the defendant failed to timely produce relevant emails and thereby prejudice the plaintiff in trying to recover it elsewhere. And they referenced the Fast versus GoDaddy case that we covered earlier this year. I didn't remember for sure that the plaintiff failed to timely produce relevant emails, but I could have missed that. Any comments on that?
Well, I think the judge addressed that in saying they got them from third parties, so that even if there was a lag by the defendant, the emails were available from another source. So I think that could be construed to address that. And I think the other thing was there was some discussion that some of the emails they simply didn't realize they were supposed to have preserved them, and said they wish they had printed them out and physically stored them, but they eventually located them. So it wasn't like they were attempting to, at least in the judge's opinion, I think, deliberately try to hide anything. Once it became clear what was supposed to be done, they did it.
Right. Well, and the emails that the defendant didn't produce that were produced by third parties were attributed to the defendant not considering those responsive or possibly being privileged.
Right.
Another good. But still a great question and to ask there. So appreciate that. So we'll move on to our next case, which is one I got various comments on, some supporting the decision, others not supporting it. In Familari versus Gannett Company, the plaintiff, a former Gannett account executive, generated and printed reports of her own performance metrics and requested the same Salesforce data for certain other Gannett employees for purposes of comparison. The defendants asserted that the reports the plaintiff produced and printed were not freestanding fixed reports, but were screenshots of the Salesforce dashboard that displays the user's real-time data. So they said they couldn't generate the reports the plaintiff requested and could only provide her with Salesforce's underlying historical data exported to a Microsoft Excel spreadsheet, which they'd already produced. After a telephone conference with the parties, Judge Hammer entered an order on the docket stating, to the extent possible, defendants shall produce the reports in screenshot format in addition to the Excel spreadsheet format already produced. Counsel shall schedule and take the Rule 30b-6 deposition of a defendant representative on this issue if defendant maintains that it cannot produce the screenshot format. The defendants appealed Judge Hammer's text order on the grounds that it requires them to produce ESI in a second format in contravention of Rule 34b-2e. How'd that go? Not great for the defendants. While noting a magistrate judge's non-dispositive order may be set aside if it is clearly erroneous or contrary to law, New Jersey District Judge William Martini stated in upholding the order, defendants have not persuaded this court that the text order is clearly erroneous, contrary to law, or an abuse of Judge Hammer's discretion. Indeed, defendants have not presented a genuine conflict between the text order and their discovery obligations. On the one hand, they argue that the text order impermissibly requires them to produce ESI in a second format, but on the other, they continue to argue that it is not possible to give plaintiffs this actual information in the form of screenshots of the Salesforce dashboard due to the dynamic nature of the platform. It is precisely because of this latter argument that Judge Hammer afforded defendants the option of providing an appropriate representative to testify at a Rule 30b-6 deposition on Salesforce's functionality and how it reports or maintains the data at issue. Judge Martini also noted the defendant's previous willingness to sit for that deposition. So, Mary, since screenshots in Salesforce are a dynamic representation of data at a given point in time, do you think defendants can even do what the plaintiff is asking for? If not, how could they have explained that better to the court?
Yeah, that is a really good question, Doug, because we're talking about a point in time. So we'd need to, have a DeLorean to get us back there to generate a screenshot of Salesforce dashboard, which is pretty much graphs last 30 days, last 90 days, last year. And so it takes a point in time. So can you do it? Well, you would be recreating it, and you're hoping that maybe if you, change the date and time on your PC, that it will generate in the right way. Not sure that would happen, but certainly the underlying spreadsheet data could generate graphs that would approximate what was seen in the spreadsheet. But a couple of things about Salesforce. You've got lists of salespeople, contacts, activities, dollar amounts, opportunities, the age of the opportunities, the disposition of the opportunities. All of that changes every single day. Licenses cost money. So if salespeople leave, those salespeople will probably be taken out of the graph. Territories and accounts change over time as well. So whether you could generate a dynamic point in time dashboard, I think they'd be arguing over whether it was authentic or not. And more than likely a pivot table could give them the visuals they wanted. And then, of course, they could have done the demo, or the depot, I should say. Could have done the depot.
Could have done the depot.
Could have done the depot.
Done the depot. That's the theme of this case, which is actually the question I was about to ask Tom. Tom, are you surprised that the defendants didn't do the depot, did submit to a 30b-6 deposition to state their position, especially since Judge Hammer encouraged them to do so?
Well, it's a head scratcher because not only did the judge encourage them to, but as you read, you can see that last sentence up on the screen, they indicated that they'd be happy to participate in such at one point in time. So there seemed to be some counter-indicative argumentation going on here. It may be that they thought they had a good argument under the 34b-2e Roman numeral 3, and so therefore they wouldn't need to because they were going to defeat any attempt to do that. Obviously, in retrospect, that was not a good assessment, but honestly, what they were thinking is a real head scratcher to me here. It's a puzzlement to me.
No, actually, I think that's a great point. Is that they may have thought they did have a great argument. So I certainly could see that as their reasoning. So so looking at that, Judge Peck, don't the defendants have a point when they say they already produced the evidence once and can't be forced to do so in a different form under Rule 34B2E3? Isn't production of the data in a spreadsheet sufficient for producing it in the form in which it's maintained?
Well, Doug, I don't know how you missed this pun, but I would say that Judge Martini was neither shaken nor stirred by the arguments.
Never joking.
But
So,
to actually answer the question, the only have to produce it once rule in Rule 34 is dependent on the document request and whether it sought a particular form of production. So if the plaintiff request, as I think it might have here, said, I want this information about comparator salespeople in this sort of form, then the defendant has to produce it in that form, or in its response say, no, I'm not going to do what you've asked for, and I'm going to do something else. At that point, assuming all of that occurred, and much too often the form of production is not requested, nor, if requested, objected to, at that point, it should have gone to the court before there was any production. So it would not have triggered the, I only have to produce it once. In addition, I am not particularly knowledgeable about Salesforce, but I doubt that the information is really kept in a spreadsheet form. So that is probably not the form in which the data is ordinarily maintained. In addition, as the court pointed out, the conflicting arguments being made by the defendant did not put them in good stead. They're arguing that this would be a second form of production, which is verboten, but they're also saying it's not possible to do it in this way. Those, to me, are not complementary but contradictory positions, which, leave a judge who doesn't know much about Salesforce scratching one's head.
Yeah, no, that's a great point. A question from the audience: doesn't the authenticity go to admissibility, not discoverability? It's not the same data any more than a movie script is a movie. So I guess that's the question here. Is the question that I wondered about is the authenticity of being able to say we can reproduce those screenshots exactly as they should be produced from a comparison standpoint. Obviously, that has to come into play when you're thinking about is that possible, and then is it verifiable? So any thoughts on that question?
I mean, there is a difference in what is discoverable versus what is ultimately admissible in court. And we just don't know, based on the data in the opinion, how much time had gone on. Was the data likely, if produced now, to be reasonably similar to what it was, at the time of the plaintiff's spreadshots? How much time had gone on? How much work had the other salespeople done subsequently? If it were trying to play with the controls on Salesforce, then maybe it would be an authenticity issue as well. But I think it's more a question of, could it be done?
Right. And to the question about it's the same, not the same data in the movie script movie, it may not be the same data, but it may be the same information presented in a different format. For example, a movie script and a movie may both contain the line, "This is the beginning of a wonderful friendship, Louis." They're clearly different formats, but it's the same information. So, you got to be careful about what you're objecting to here, I think.
Oh, that's a great point. It's a very interesting case, and amazing. We just have a lot of interesting cases this month. So I'm going to move on to the next one, which may be even as interesting, if not more so. By the way, just a reminder, because Scott asked the question again. Yes, we will send out the slide deck after the webinar. So rest assured, you will receive it. All right, so our next case is another one that Judge Peck suggested, and it gets into eDiscovery functionality that a lot of us use regularly and maybe some of us even take for granted. This complex antitrust class action was filed almost 8.5 years ago, and in early 2015, the court approved the discovery protocol that the parties proposed. That protocol called for production of ESI in native format with metadata, encoding fields, and deduplication, but it stated nothing about producing only the most inclusive emails and email threads. After a lot of motion practice and 2 Second Circuit appeals, Takeda finally began to make multiple rolling productions in February of this year of non-privileged documents from 25 agreed custodians, including 6 in-house lawyers. In its production, Takeda used email threading, reviewing and producing the most inclusive email in a thread, or emails in a thread. The plaintiffs objected and filed a motion to compel Takeda to produce lesser included emails and their associated metadata, as well as privilege log entries for earlier in time emails that are part of email threads redacted or withheld for privilege. New York Magistrate Judge Stuart Aaron stated in ordering Takeda to produce all responsive ESI2 plaintiffs, including earlier in time emails, stated Takeda's exclusion of lesser included emails from production has resulted in the exclusion of the metadata associated with earlier emails in a chain, which may be weeks or even months prior to the last email in a chain. This exclusion materially has reduced plaintiffs' ability to search for all correspondence within a date range. In addition, in certain emails, only the sender of particular emails earlier in a chain are reflected, and not the recipients of such emails. Finally, Takeda's email threading has removed plaintiffs' ability to see if anyone was blind copied on lesser included emails, even though this information was among the metadata the parties agreed in the discovery protocol to produce. Regarding the privilege log dispute, Judge Aaron stated, because the court now is requiring Takeda to produce earlier in time emails, which will affect the scope of the privilege log, the parties may be able to reach an agreement on the privilege log issue. Accordingly, the parties are directed to meet and confer to seek to agree on a revised privilege log protocol, taking into account the court's ruling above. He also discussed the idea of using categorical privilege logs, stating categorical privilege logs are appropriately used in this court, while rejecting both parties' proposed approaches to categorical privilege logs. So, Tom, many eDiscovery providers tout their capability to put aside lesser included emails in a thread and limit review to only the fully inclusive emails. Do you think this decision changes whether parties will continue to use this feature or change how they use it?
Well, I hope so, because I've never been a fan of that feature for 2 reasons. One, I think it's a great example of how technical people come up with a great technical feature that perhaps they really shouldn't be doing. Is that something you want the technical staff to be doing automatically without anybody looking at the actual bodies of the emails? The idea is an interesting one, but I'm not warm about it. The second reason is the one the court elucidated, which is it eliminates metadata for the older versions, which may be important, critical, and certainly relevant. So, I don't like it. What's really interesting to me here, though, is that the protocol that the parties had agreed on didn't allow for it. So in one sense, it raises the question in my mind, I don't think it was really addressed here, but did the client know that the technical company was doing that? Even though the client, the lawyers, had agreed to do something different in the protocol. Who was minding the store there? And how did that happen without their being aware of it? So if this decision leads to better oversight of some of the technical processing of data, I'm all for it.
Sure. And Yeah, I think it's very interesting. It didn't really address that you could do that, and obviously these are terrific issues you bring up with regards to the lack of metadata for those lesser included emails. So shifting gears for a moment, Judge Aaron raised the consideration of using categorical privilege logs and said they're appropriately used in his court. When should parties consider using them, and are there reasons not to use them even for cases with a lot of privileged documents?
Okay. I mean, I will say it is not a coincidence that our local rule on privilege logs was amended to encourage parties to cooperate and to use categorical logs where appropriate at a time where I was the Southern District co-chair of the joint Southern and Eastern District Local Rules Committee. You know, if I were revising that today, I would probably say to consider using categorical logs or metadata plus privilege logs. But be that as it may, the problem with categorical logs is, can the parties agree on appropriate categories? I mean, sort of the universal category is documents between the client and outside counsel after the trigger date, whether that is the date of filing the complaint or some other appropriate date. That's an easy one. And usually there, you don't even log anything. You just say, those are off the table. But, you know, what information will be given for each category? Categories work best when whatever either factual or legal issue is raised by the category is then ripe for judicial resolution. So it may be the category is, you know, all communications between the counsel, client, and their outside PR firm. You don't need much more logging than that to present the question to the judge for resolution. Is that outside PR firm within the privilege, or does it break the privilege? You know, a category that is advice from in-house counsel to client employees is probably not very helpful because it doesn't clearly distinguish between business advice, legal advice, and worse, perhaps mixed business and legal advice. Mm-hmm. But the so-called traditional document by document privilege log, which has become traditional, but the 1990 was either 93, 96, somewhere in the dark ages, when 26B5 was put into the rules, the advisory committee notes clearly indicated that document by document may be appropriate if there aren't many documents on the priv log, but that in other cases, categorical or other means may be appropriate. And just to go back to comment on what Tom said, I don't think the ESI protocol forbade having the emails logged as one, as much as it was just totally silent. They either didn't consider it or didn't reach agreement, and that left the issue for the court to decide. And yeah, the one other practical point, when I was on the court and parties would, at my suggestion, pick, 10 examples of privileged documents that they were challenging for me to look at in camera, when they didn't do a when each of the emails in what could have been a chain were put on the log separately, I have to tell you that many times of their examples, 3 or 4 would be pieces of what would be a bigger chain if it were put up. So there are good reasons to do it as an email chain, and also good reasons not to do it as an email chain for the reasons Tom was mentioning.
Yeah, absolutely. And I appreciate the thorough discussion of categorical privilege logs. I certainly think we're going to see a lot more of those in large, especially large cases like this. And thanks for addressing one of the questions of the audience where they are asking about that particular issue, whether it was specifically stated in the ESI protocol. It's our understanding it wasn't. It just wasn't mentioned that they could, is our understanding. So speaking of disputes about ESI protocols, Mary, this dispute didn't come to light until Takeda began producing documents. So what can parties do, if anything, to flush out potential areas of dispute in an ESI protocol before productions begin?
Oh, that's the production sample. And, doing that very early and not on the eve of the discovery cutoff date for sure. But categorical privilege logs and the metadata involved and the individual emails contained in the thread aside, there's also disputes sometimes about spreadsheets with formulas, PowerPoints with comments and notes, words with track changes, whether or not you get the BCCs in CCs, as in this case, calendar items, and of course the threads. So memorializing it in a scheduling order is great, or at least by memo after the meet and confer. And I would just say that categorical logs are a fabulous thing, and having the ability to have the dates and the senders, recipients, the subject line, and everything, those metadata for the pieces, I think are that's a really important thing. So I think it's important that samples go early so that a reaction can happen outside a motion practice.
Yeah, agreed. I think that's a practice a lot more parties should consider. Somebody notes in the comments real quick before we move on that you can have a little bit of both. You can certainly do inclusive email threading for review and quality control of coding, but still produce the exclusive emails or the lesser included emails in production, and so kind of satisfy both needs. Certainly, I think a topic that was unique and we may see more of. So I will move on because we've got two cases to cover and a little less than 13 minutes. So, and I just moved past. There we go. All right. So I don't know whether the theme song for this next case should be A Hard Rain's Gonna Fall or Love, Rain, or Me, but this is the second of our true trademark infringement cases involving similar names. Though they're spelled differently and seem to be pretty different businesses. Regardless, the parties had negotiated an ESI protocol again, but still had a couple of disputes, and the defendant submitted proposals for addressing the two disputes, asking that certain language regarding the parties' search obligations be included in the ESI protocol, including an expectation to conduct a reasonable search in all company files and to not limit to the 6 custodians that plaintiff identified having responsive ESI. As for search terms, the defendant proposed limits on terms lawsuit, hedge, private equity, venture capital, trademark, and sophisticated, and proposed that plaintiff search for the term real estate within 30 of invest or manage or sell or sale. The plaintiff objected to the term real estate, even with modifiers, stating it was unduly burdensome as it resulted in 1,800 hits per single custodian, argued that no modifiers were needed for lawsuit and trademark because each side was searching for the other's name as standalone terms, and agreed to the other limitations proposed for lawsuit, trademark, and sophisticated. The defendant dropped limitations on hedge fund, private equity, and venture capital. Feel free to go to the blog post to see the actual search terms proposed and discussed, either to eDiscovery today or click on the link when you get the slides. Regarding the first ESI protocol dispute, New York Magistrate Judge Catherine Parker stated, to the extent the requested language suggests that the parties must search all company files or all files from all employees, the language is overbroad, noting that the plaintiff is a merchant bank with over 100 employees suing a 2-person real estate development and management firm. Judge Parker did advise plaintiff that searching non-custodian sources likely to have relevant information was part of their obligation under Rule 26. Judge Parker also stating search terms, while helpful, must be carefully crafted. Poorly crafted terms may return thousands of irrelevant documents and increase rather than minimize the burden of locating relevant and responsive ESI, ruled that the term real estate was overbroad even with the modifiers, and that defendant could explore the business overlap between the parties in a 30v6 deposition. She also ruled that plaintiff does not need to include its own name in a modifier for the term lawsuit, and that for the term sophisticated trademark, the proposed modifiers make sense as they appear to be more focused on the issues relevant to this. And finally, because the modifiers possibly narrow the universe of returns, the court will require plaintiff to accept them for the defendant-only terms. Nobody seemed to acknowledge that lawsuit is frequently represented both as one and two words. So Judge Peck, this case and the previous one involved disputes regarding the protocols. I heard Texas Judge Xavier Rodriguez say in a couple of recent webinars that he's not a fan of ESI protocols. What do you think about it?
Yeah, I mean, the problem is this. There are certain things that must be decided up front in a protocol, including whether email threading is permissible or not, form of production, some other key issues. But because lawyers try to cover every eventuality, no matter how unlikely to occur, it becomes, a multi-month negotiation of eventualities that probably will never come to pass. And that is the problem. The parties are afraid that if they don't cover it and something comes up, they may be stuck. And so perhaps the best way to have both worlds, a good protocol, but not take more time than it would take to do discovery, is to have some sort of, have cooperation, including a carve-out clause that if something isn't covered and comes up down the road, the parties get to negotiate over it and take it to the judge if necessary. And just as an example, we talked several months ago about the Valsartan case where the TAR protocol that was in the ESI protocol wound up binding the parties even when it became unworkable. And the judge basically said, you agreed to this protocol, you presented it to me, I so ordered it, you're stuck with it, in essence. So, have it be sufficiently binding that it's productive, but have some sort of get out of the protocol if something comes up that wasn't anticipated. That, I think, would shorten negotiations and shorten protocols considerably.
That's a great point. Yeah, carve-out clause is a great idea because it does seem like a lot of these ESI protocols do wind up as disputes in court. So, Mary, Judge Parker stated that the defendant's proposal for parties to search all company files was overbroad and noted that the plaintiff had over 100 employees while the defendant had 2 employees. Should size of the parties matter when considering producing responsive ESI in discovery?
Well, it seems like a reverse proportionality factor in a certain sense. So we've got the number of employees, 2 versus 100. And so we're trying to limit the 100. But it's also a kitchen sink request. It's like all of everything without narrowing it down. And so, you're going to be looking for the relative access of the parties' resources, certainly in proportionality. But narrowing it would have probably been the thing to do, I think.
Sure. And yeah, absolutely. I guess there is a limit to obviously how broad you can go, regardless of size of company. So Tom, here's yet another case where the court has to make a ruling on the scope of search terms without a sense of how broad or narrow they are for the given document collections, at least other than maybe one term where we did get a hit count. Should courts order parties to submit hit counts of searches to aid in scope rulings?
Yeah, I suppose they could. My puzzlement is, why are judges still getting involved in this? I mean, didn't Judge Fasciola talk about the folly of this in 2008 in the O'Keefe case, saying that for judges and lawyers to decide what's the best way to do a search is where angels fear to tread? And Judge Gruhl said in 2012, there's no magic to the science of search and retrieval, only math, linguistics, and hard work. Judge Francis in 2017 in the New York taxi case said the party has not produced any expert opinions for me to even make an assessment about what's going on here. And of course, our very own Judge Peck is renowned for saying, bring your geek to me. Bring me your geeks. Why are we getting bogged down in this? And that's not even going to the, why are we using search terms and not tar? The fact that we are getting bogged down with judicial resources in search terms like this is still a puzzlement to me.
Yes, I can relate. I'm sure judges sometimes feel they have no choice, but yeah, there are still cases where you can say, well, why not, force some sort of information that's more than just based on judgment. So it's certainly interesting to note here, and another interesting case. And we have one more, which we will really try to expedite here as we're getting close to the top of the hour. As my doggie, who's been hiding under my desk this whole time, decides she finally wants to come out. So apologize for the background noise there. So our case takes us way back to January when the ruling happened, and this case was suggested by Tom. In Weinhofer versus Davy Shoring, Inc., a contract dispute over the terms of an online auction, Henderson Auctions advertised and hosted the auction on its website, but when auction participants clicked on the link to bid, they were directed to ProxyBid, a third-party website where they could view the auction's terms and conditions and place their bids. Among these terms was a term declaring that bidders would be liable for only 20% of the bid price in the event of a breach of contract. After the auction, winning bidder Davy Shoring refused to pay for the module when it proved difficult to remove from storage, leading to the suit. At trial, Davy Shoring introduced the auction terms and conditions in two forms, as an internet printout labeled Exhibit 41 and as an archived webpage from the Wayback Machine. Exhibit 40 was introduced through the testimony of Renita Martin, Henderson's office manager, but she got them from ProxyBid's website to produce them in response to the subpoena since they weren't on the Henderson site anymore. The district court ruled that Martin had properly authenticated Exhibit 41 because, although she wasn't its author, her job description indicated that she was a proper custodian. The district court also took judicial notice of the terms and conditions as they appeared in the archived webpage, explaining that the archived webpage was a source whose accuracy cannot reasonably be questioned under Federal Rule of Evidence 201, and entered judgment for Weinhofer in the amount of $35,500 plus costs. Weinhofer appealed. The Fifth Circuit stated Martin had no personal knowledge of the terms applicable to the auction. Martin had to search a third party's website to obtain the terms because Henderson did not have them in its possession. Moreover, Martin's testimony indicates she was unfamiliar with ProxyBid's website and that she needed the assistance of a colleague to locate the terms. Thus, Martin's authentication testimony only amounts to an affirmation of her memory that Exhibit 41 is what she found on the internet. The district court abused its discretion by relying on inadmissible evidence when it reduced Weinhofer's damages. We accordingly reversed its ruling. As for the Wayback Machine evidence, the court stated, in this circuit, a district court found that documents from the Wayback Machine were not appropriate for judicial notice, citing the Wayback Machine's terms of use, which disclaim any guarantees of accuracy regarding content stored there. Here, there was no testimony to authenticate the archived webpage. Our sister circuit's decisions that the Wayback Machine is not self-authenticating are persuasive in the context of judicial notice. In sum, the district court erred in taking judicial notice of the terms because a private internet archive falls short of being a source whose accuracy cannot reasonably be questioned as required by Rule 201. So, Mary, do you agree with the court's statements about the Wayback Machine's disclaimer of accuracy and lack of testimony to support its authenticity as reasons that evidence isn't authenticated, or are you surprised that the court ruled against its admissibility?
No, I'm not surprised given all of this. If you skipping ahead, in the decision that we're looking at to distinguish it, that plaintiff has presented no evidence that the Internet Archive is unreliable or biased. Here we have a statement, a disclaimer saying that it's not to be relied upon. So additional testimony would be necessary, I think. And the Internet Archive doesn't archive everything, and you can archive things yourself up in there. So I think you might get a rebuttable presumption, but I'd be very careful about evidence coming out of the archive.
Fair enough. So, Tom, in a case with Judge Grimm that I think you mentioned to me from a few years ago, he ruled evidence from the Wayback Machine was admissible. Is this a case of inconsistent rulings, or were the circumstances different in that case that led Judge Grimm to conclude differently?
Well, I think the circumstances were different. In the instant case, the court was taking judicial notice of the information on the Wayback Machine. In Lorraine versus Markle, Judge Grimm took an affidavit from the representative of the company and said that was sufficient to satisfy Rule 901's threshold requirement for admissibility, which requires only a prima facie showing of genuineness, and that the actual question of true authenticity and probative value of the evidence is ultimately left to the jury. So I think clearly a different set of circumstances and how the evidence was introduced.
Okay. So Judge Peck, Judge Martini, in the previous case, declined to reverse Judge Hammer's ruling in that case regarding Salesforce data, stating it wasn't clearly erroneous. Are you surprised that the Fifth Circuit here found the district court's ruling erroneous and reversed it, or do you agree with their ruling?
Well, I think there is a difference in the standard between a discovery ruling by a magistrate judge, which, as Judge Martini said, gets the greatest deference, and a trial evidence ruling, whether by a district judge or in a case where the magistrate judge is trying the case. That's an evidentiary ruling, which, there can be a right or wrong answer. There can be gray areas, but that's, something that can go up to the circuit. I probably would have found enough to take judicial notice of the Wayback Machine here, but just, a note of penny wise, pound foolish lawyer behavior. If you look at footnote 22 in the Weinhofer decision, it shows that for around $350, the party could have gotten a certification as to the information from the Wayback Machine that would have made it admissible under Rule 901, which is similar to the way it was presented in Grimm's case. It probably technically doesn't qualify for 201 judicial notice, but it, in most situations where it is saying what is actually in an archived website as opposed to, what wasn't in a website at a certain time or other things, probably, if not objected to, would have come in most courts, but it's the old problem with authenticity and admissibility. You don't want to, as a lawyer, necessarily take the time to dot the I's and cross the T's during depositions or discovery, because of course the judge is going to make the other side agree to get things into evidence without taking a lot of time. And then lo and behold, the judge doesn't put the other side's feet to the fire. They don't stipulate, and you're left unable to get the information in. Preparation, preparation, preparation.
Yeah, well, and interesting, $350 may be costing them what the other 80% of the auction amount here when it's all said and done. So definitely probably a wish they had a do-over on their part. So I'm going to move to the contacts page here because just in time, we do have a date for our next case law webinar, which is on Thursday, June 30th at 1 p.m. And eDiscovery case law is heating up, and you'll probably hear that pun again next month. We do have a couple of additional questions I can circle back to real quick. I know we're past time here, but we appreciate all the great questions we got this time. So back to the very first case, someone's asking, does the opinion speak to whether Target had a records retention schedule that wasn't followed with respect to the reported issue? I don't recall that it mentioned anything about a records retention schedule in that case. So I don't know if anybody else did remember it, but I certainly didn't remember that it mentioned that as part of that case.
Yeah, I don't recall seeing anything either, Doug.
Yeah, it was not discussed, but there are cases that say a party's own record retention policy does not and should not create requirements to preserve information beyond what is required by the federal rules and the common law on preservation.
Okay, well, no, that's a great point. So great answer there. And then a question from the Salesforce case: can the producibility of dynamic data be held to the same standard and requirement in Discovery as static data, spreadsheets, docs, etc.? I think that's one of the questions I saw a lot when I posted the post is dynamic data versus static data. Any thoughts about that question?
I mean, obviously, you can't shut down a business just because a lawsuit occurs or is anticipated. If it were crucial data, maybe there would be an obligation to, in some way, freeze the database, make a copy of it before you do additional business work with it. But dynamic data is going to be a problem in any litigation.
Yeah, absolutely. And then finally, somebody has a comment about parties discuss search terms in these cases, but never search syntax. And they use the real estate search as an example, which could have been interpreted a couple of different ways. And that's certainly one of the things, obviously, when we're debating these terms, they note that there was no grouping of terms when they probably meant for the investor, manage, or sale terms to be grouped along with the within 30 of real estate. So absolutely, that's one of the things with the search term disputes in case law is I look at some of these terms and I automatically see variations to the terms that they're not really discussing in the case law. So you're preaching the choir to me on that one. Anybody have any thoughts there?
Mm-hmm.
All right. Well, we again appreciate all the questions. Sorry we couldn't get to all of them, but Mary, I will turn it back to you to close this out somewhat late.
Indeed. Well, thank you, Doug, for anchoring, and thank you for sending the slide deck after the webinar. I know we had a lot of people asking for that. And thanks to Tom O'Connor and the Honorable Judge Peck for this insightful presentation, and our thank you to the EDRM community for your kind attention. So tune in tomorrow, and then, of course, again next month for our case law webinar for June on the EDRM Global Webinar channel, and we'll see you in Chicago.